May it please the Court, I'm Joshua Gordon. I represent Kerry Kidd, who alleges his trial attorney provided him ineffective assistance. Now, implausibility here would have been a good defense because it is unlikely that a rape could occur with a dozen people in tents just a few feet away. And reading the entire transcript in this case is instructive. It shows the attorney gave a lackadaisical representation at trial, whether because he was professionally tired, had lost faith in his client, or because of his mental health issues. In this case, there was no physical evidence. This was a he said, she said type of trial, making testimonial inconsistencies the entire game. Ignoring them was not merely a strategic choice. And I'll give 4 examples of inconsistencies that weren't explored. A.H., the minor, told an officer that she slept in her own tent, and one of the witnesses said the same thing. A.H. told another officer that she shared her tent with another. At trial, A.H. chose the solo tent story, and whether she was alone in her tent or sharing it makes a difference because it is unlikely that a rape could go unnoticed in a small 2-person tent. The attorney didn't confront the complainant with any of this. Similarly, there's a question about whether A.H. resisted the assault. She wrote a letter that, saying she kept pushing him away, and the adult to whom she allegedly reported said the same thing. At trial, however, A.H. testified that she just lay there not doing anything. This is important because pushing would make noise, it would create jostling, it would likely wake the person next to her in the small 2-person tent, making her story implausible. And the attorney just ignored this discrepancy as well. Third, A.H. told one officer that Mr. Kidd rubbed her back. She told another that he rubbed just her stomach and her privates. On cross-examination, she couldn't remember if her back was rubbed. On direct, she testified she was laying on her back.
Can I ask you something else?
Yeah.
Did he cross-examine on some inconsistencies?
Yes. Yes, there were, yes.
Okay.
Yes.
And so the argument is what? That if he had cross-examined on all of them, what would have occurred?
In my brief, I lay out the 16 or 18 that I saw as most significant, and I don't think it's necessary that he would have cross-examined her on all of them, but some of them make a difference. Some of them raise the issue, like I just discussed a moment ago, that, you know, how could so many people so close, in such close quarters, not know this was happening?
Could you have, I know when I tried cases, they weren't criminal, but they were civil cases, and sometimes you could impeach a witness 30 times based on their deposition. And after about 5 times, you stopped because the point had been made. And if you went much further, suddenly you would not be very popular. So why couldn't, in a case where there were multiple inconsistencies, as you say, the lawyer talks about some but not all, why couldn't that lawyer have the same feeling I used to have, which is, I think the point's been made?
Read the record. The point really was never made. For the number of witnesses.
That'd be hard to tell from a cold record.
It's hard to tell from a cold record. I understand that.
And didn't your expert attorney Osler admit at this hearing that it was much better to raise 5 or 6 inconsistencies than a bunch that may have been mushy? I mean, even he apparently identified 60 to 7 possible inconsistencies, but then agreed that raising a handful is the better tactic.
Absolutely, of course that's true. But there's a point at which you have to raise some important inconsistencies, because that's really the only thing he's got. And to let so much go by looks like it's just lazy. Can you switch for, because I see your yellow light is on, to the issue of the term victim? Yeah. I get from reading the transcripts that what happened was 2 juries were selected, and during the jury selection, the court asked its usual voir dire questions and used the word victim as opposed to alleged victim or complainant. Given this circumstance where 2 juries were selected and the term victim wasn't aimed specifically at this case,
why do you still argue prejudice, incurable
I think
prejudice?
prejudice may even be more manifest because the word victim was used in voir dire. This jury was essentially instructed on the ultimate outcome before they even met the defendant. It might be different in a case where it's clear that a crime occurred, but like a whodunit type of case. But here, where the ultimate issue is whether a crime occurred, using that word, which implies, I think most clearly, that a crime has occurred, essentially directs a verdict against the defendant before the jury has even has learned his name or met him or heard his story. See my lights on? Thank you.
Thank you.